Aloha. Welcome to American Issues Take One. I'm Tim Apicella, your host, and today's title is Supreme Court Ties Judges' Hands. Executive orders can avert the law. Since the Supreme Court in the case of Trump versus the United States, they gave Donald Trump presidential immunity as in his role as president, was a pretty monumental case. Very, very big decision. The type that create kings rather than presidents. And we haven't seen a decision like that in decades, if ever. And so recently, the Supreme Court in Trump versus CASA Inc. has on equal footing to the immunity decision, a case that curtails any federal district judge the ability to order a nationwide injunction for a case found to be in violation of the United States Constitution. In other words, it handcuffs these judges from stopping a presidential executive order that is clear violation of the US Constitution and the rule of law. And we're here to talk about that today. And with me, I have our two esteemed guests, Chuck Crumpton, attorney and mediator here in Honolulu, and David Larson, professor of law at the School of Mitchell-Hamlin. And of course, with me always is my co-host and CEO of ThinkTech Hawaii, Jay Fidel. Jay, let's run right to it. One heck of a decision. Not a good decision, but it is a decision, and it's the law of the land. So what's your read on the SCOTUS decision of Trump versus CASA Inc.? And how do you see what is the worst aspect of this decision that the Supreme Court has made?
This falls in with U.S. versus Trump on the immunity issue. It falls in with Robbs on the Roe v. Wade issue. It falls in with Citizens United even. I think it will have an enormously detrimental effect to our democracy. You know, we lost Congress somewhere along the way. The president Trump is likely to violate the Constitution every time you turn around and issue executive orders that do exactly that. He's trying to be a dictator. We relied on the federal courts. We relied on the federal courts as the last branch of government that could stop him. And that, unfortunately, the rug has been pulled out from under them, where before they could issue nationwide injunctions. Now they can't do that anymore on constitutional issues. So it's a profound change. It's a disaster for the democracy. It is monumentally bad. And it's, as you said, it's the law of this land. So if a presidential executive order is determined to be in violation of an article of the Constitution, now the party filing suit against the order gets the relief from that judge, but no other parties. And if the country is adversely affected by the same unlawful presidential executive order, so what? This is a limitation of the powers of the judiciary, of the district judges. And, you know, what I've been thinking about is, I guess the Supreme Court is telling us they're too busy. They don't want to handle all the appeals from all these nationwide executive orders because there are plenty of them, because Trump's executive orders are largely wrong and unconstitutional. They don't want to handle those appeals. They want to leave it to the bottom, to the district judges to handle multiple cases from multiple plaintiffs in multiple situations, all again involving issues in violation of the Constitution. This is really pulling the wings out of the Constitution, and there's no good reason for it. I talked to one guy who said, "Well, wait a minute, you know, this is one of those Pandora boxes cases because if you stop this from happening when the Republicans are in power, then you're also stopping it from happening when the Democrats are in power." But the Democrats haven't done this. The Democrats are not particularly interested in violating the Constitution. And Trump is increasingly interested in violating the Constitution. And so I told him I disagreed with him. But there is a Pandora's box argument here that what's good for the goose is good for the gander. But I think circumstances and the present situation in the country demands national injunctions, and we no longer have that.
Well, let me ask you this, because I'm not clear, and this also goes for David or Chuck, if you guys know, but does this decision that hampers or ties the hands of district judges if they come up with an injunction, does that only apply to the plaintiffs of that case, or does it apply to the district or the boundaries of that court district and any jurisdiction that lies within?
It only applies to the plaintiffs in the case, and it only applies in that federal district. So it's really, cutting off constitutional litigation at the ankles.
So if there's another jurisdiction where the exact same case or situation, and in this case it was citizenship issues, I believe deportation issues. So if there's another jurisdiction and a similar deportation issue, that district judge ruling will not apply, even though it's in the district, the court district will not apply for that individual. Did I have that right?
It only applies to the parties in front of the judge
Okay.
in the district in which the litigation is pending.
Okay.
Now, there are exceptions, but Clarence Thomas and Neil Gorsuch gave us warning about those exceptions. They said, oh, you guys are going to try to get around this. You better watch out because the Supreme Court is going to limit those exceptions. And one of them is Rule 23, class action suits. Okay, that's a logical possibility. There have been class action suits where this plaintiff and others similarly situated, even across state borders, are entitled to injunctive relief. However, if you look at Rule 23, you get eye strain. You know what I mean, Chuck? You get eye strain. You have to read and read and read and all this judicial gloss and lots of language and all this. And on top of that, Thomas and Gorsuch are saying, oh, we're not going to let you do that so fast. So although people talk about relying on this, class action alternative approach, and the ACLU is already trying to recast its litigation as class action, we can expect some resistance at the Supreme Court. Furthermore, and this is really important, time is of the essence in dealing with constitutional issues. A lot of people are affected, country is affected. And in order to get the class action certified, it takes a long time, months, maybe years. And so, when Thomas and Gorsuch, warned us about this, and when the court opened this sliver of a possibility, it isn't real. It's Tom Sawyer and the picket fence. It's not necessarily going to take us anywhere. There's another exception involving the Administrative Procedures Act, where a ruling by the executive, which is considered arbitrary and capricious, can be stopped on a larger national injunctive basis. However, arbitrary, capricious, what does that mean? You want to leave the definition of those terms up to our Supreme Court? I wouldn't. I don't trust them. Sorry.
Yeah, good point. Chuck, before I ask you what your take is on this ruling, is it conceivable that the president can explicitly, with full intent, knowingly violate the United States Constitution and any article within, and knowing full well that it would take months, if not a year or more, before it would be challenged legally, either through an appeals court or up to the Supreme Court?
Yes, and in fact, he's been doing that for the last 5 months and change. So
is this decision a green light for him to continue and do it with impunity?
As far as he's concerned, and nobody's opposing him. He's not getting opposition from the U.S. Supreme Court. He's not getting opposition from the Congress. And so what's to stop him? And the lackeys that he's chosen are there to do what he wants. But I think your question raises some really important points, that it's just as important what is not said and not addressed in the CASA opinion as what is. One of the things that's not addressed is, if this is a major, important U.S. constitutional nationwide policy question, which it is, there's no question about that. Birthright citizenship applies to many, many people across the country and some outside it. The remedy that's provided is quick avenue to the Supreme Court to at least evaluate the merits, at least decide on the likelihood of success, and look at the adjunctive relief, the equitable relief on that basis. And they've avoided doing that. Instead, on the procedural jurisdictional limitation. They've limited the scope of it and basically sustained Trump's attack on the authority of the courts to be able to prevent illegal, unconstitutional action. The second thing that they've not talked about, we've never in our history, as far as we know, or as far as the printed history and publicly available history has shown us, had a president who essentially came in and for the first 5 months of his tenure, issued as broad, unconstitutional executive orders and gave them the force of law. If you look at the Supreme Court's opinion, they're essentially equating the executive order with a statute, but a statute comes from Congress with the authority to issue it. The executive order questions that very authority, and the Supremes have chosen not to address that. So they've done exactly what you and Jay have said, which is they've delayed the protections of the constitutional rights that have been enshrined for several hundred years in this country in order to defer to an imperial executive. And they basically come out and said that.
So the No Kings protest actually was very appropriate to have, because that's what we have, thanks to these two rulings of immunity and, of course, district judges not being able to apply a nationwide injunction, something in violation of the United States Constitution. Thank you, Chuck. David, I'd like to get your take on this ruling as well. Do you see it any differently than Jay and Chuck, or how do you view this?
Yeah, I guess I see it very similarly. It's disturbing. Is there anything you can do? Well, there is. Presidents can be impeached for constitutional violations. Is that going to happen with this Congress? And it's not going to happen with this Congress. You can still file separate lawsuits, but you got 94 federal districts. So it's going to be a very difficult effort to try and coordinate a national response with 94 different federal districts. States can still bring actions on behalf of the residents, so you can get statewide relief. But again, to get any kind of national relief is going to be troubling and problematic. This goes way beyond birthright. I mean, think about all kinds of environmental situations. One thing that's been proposed is that, well, you can always do class actions. As Jay was alluding, there's some challenges with class actions. You got to prove numerosity, you got to prove commonality and typicality, and that you've got somebody that's a good representative for the entire class. Well, when you're talking about environmental litigation and you're talking about different geographic locations, trying to prove that commonality and typicality for different geographic locations is going to be extremely difficult. So to say in an offhand manner that class actions are an available route and an adequate route is an exaggeration. They're not. It's too difficult to bring an effective class action. So yeah, we're at a troubling point right now. This particular case was an interpretation of a statute. If Congress wanted, they could just write a new statute that says that you can grant nationwide injunctions. They read this statute to say that it didn't permit nationwide injunctions. Well, just write another, pass another statute that does permit nationwide injunctions. But of course, this Congress won't do that. So again, as we sit here today, we're kind of frozen in time with a Congress that is just inert. They're unwilling to do anything. And as we sit here today, watching what's unfolding in Washington, they're going beyond not doing anything. They are now actively betraying their own constituents by passing a bill that's going to be catastrophic for millions of people. So they're getting worse all the time. I think what's happening today is worse than what's happened up until now, when they've just kind of stood back and let things happen. They now are active participants in hurting their own constituents. So the idea that Congress is going to step on past legislation to expand the Judiciary Act of, I think it's 1789, to allow nationwide injunctions, it's just not going to happen.
Okay, so put on your political hat now, David. And like the big, the big ugly budget bill, where Democrats are saying this is going to impact Republican Congress, both the Senate and the House, in the 2026 election, the midterms. Do you see this court decision doing the same thing? That if people are really disturbed about how the president can issue executive orders in clearly violation of the United States Constitution, does that encourage people to go to the voting booth in the midterms and say, we need a Democratic House and a Democratic-led Senate?
I think it's always a challenge of connecting the dots. Getting people to understand how certain things happen that are harming them. I think it's more difficult to connect the dots with this recent Supreme Court decision to kind of explain what it means when someone passes an executive order that no longer is subject to a nationwide injunction. I think one things Democrats have failed to do is kind of move beyond details. They've kind of gotten bogged down in the specifics, and they've lost their audience. I think that's what's going to get the electorate to respond more, is to connect the dots between this new bill and the cuts to Medicaid and Medicare. The taxes on universities, the damage that's going to happen in the SNAP program. That just doesn't affect people that rely on food stamps. It's going to affect the grocery stores that get money for those food stamps that allow them to expand their inventory, hire more people. I mean, people often think, well, it's not going to affect me, but it is going to affect you, because on a lot of these programs and policies, there are many entities that are affected by these changes. So in terms of getting motivated an electorate, I think that this new bill, which I'm afraid is going to pass today, because once again, we got a Congress that has no courage at all. I think that's going to be a tool for really motivating the electorate.
Mm-hmm. Okay. Thank you, David. Jay, David mentioned one of the remedies to the Supreme Court decision, and that is the possibility of each state enacting its own laws that pertain to address these issues of birthright citizenship or a whole host of other things. Do you see the states, similar to the Dodds decision, taking a path unto themselves and coming up with legislation that bypasses the federal statute?
That is a third option. I mentioned class actions.
Mm-hmm.
They let a little light shine on that one, but they're not going to help. When it gets to them, they're not going to help. And the arbitrary capricious test of the Administrative Procedures Act, and that's a third option, to have states file within their state declaring something unconstitutional. But I'm not confident. The Supreme Court did not mention the viability or efficacy of that approach, by the way. But it is an approach, and it was covered in a number of articles I saw. I don't think the Supreme Court is going to allow that one either. Bottom line, though, is that the whole notion of challenging something for being unconstitutional has been made much more difficult and expensive. For example, state by state, that's kind of cumbersome, isn't it? There's 50 states, and you have to get them together. And I don't know, you could get 3 or 4 or 5. I'm not sure the Supreme Court would respect that. And if you wanted to do it right, you get all 50 together. If you wanted to do it right, you'd get decisions involving individual plaintiffs or class actions in 50 states. But that's probably not going to happen. It's very expensive. You can't hire lawyers everywhere to mount these cases. The ACLU does not have the money to mount all these cases. And at the end of the day, it's a question of logistics and money to see whether a change can be accomplished through any of these methodologies. So yes, theoretically, but no, practically. And I think what we have here, and I think it has to be clear from this discussion that the Supreme Court never ruled on birthright citizenship. It never said it was either constitutional or unconstitutional. And now the people who arguably qualify for that don't know. They don't have an answer. And there's a lot of other issues that have come up just like that. This is a serious problem. We don't have the ability to rule on constitutional issues, from the bottom up. And the Supreme Court would be happy enough leaving it in chaos. So I think they have granted Trump an enormous benefit, a huge amount of power. And one more point, and I'll get off, and that is this. We have been assuming, just as we assumed that the judiciary would protect the democracy, we've assumed that until last week. We also assume that at the end of this election cycle, people will be able to speak on these issues and they will be ticked off. They will be ticked off about everything the Republicans are doing, and including the big, beautiful bill, which I agree with David is likely to pass and become the most awful, monstrous law you ever saw in the history of the country. And for that matter, this CASA case that we've been talking about. However, as ticked off as the electorate might be, if you can act unconstitutionally at will, which this case gives Trump the power to do, then you can screw up the election process, can't you? And that's exactly what's next on his agenda. He's going to screw up the election process. It's only next year, and then in 2028, so that he has an unfair advantage, or that people don't vote. It's an emergency. We can't have an election now. We have a mouse that roared war somewhere, and I have decided that it's an emergency, and we don't have election day. And you can say that's unconstitutional, but you can't get it up to the Supreme Court for a declaration along those lines. So I am very worried that the impact here is as great as any case we've ever seen in terms of undermining the democracy on critical things like voting.
Good point. Excellent point. And I share your concern about election law initiatives here in the next 6 to 12 months. Thank you, Jay. Chuck, these Supreme Court cases are really not going in favor of the legal challenges. Donald Trump is getting victory after victory with these Supreme Court cases, other than temporary injunctions. The question is this: when he issues a unlawful executive order that's in clear violation of the Constitution, is the strategy best to leave it alone? Because if you're losing with these Supreme Court decisions and it becomes law of the land, and it will sit there until Congress can fix them, which may not be until the midterm elections, is a strategy, would there be a good strategy to just leave them alone until that midterm election and just let it sit there and do its chaos?
No, because as you and Jay and David have pointed out, they've intentionally put off deciding on whether the acts are constitutional or not. The very, very great majority, approximately 3/4 or more, of the federal district courts that have ruled on Trump's executive orders have found them unconstitutional, whether it's layoffs or birthright citizenship or most of the others. So you have to get to those questions, and they have to get up to the Supreme Court. What they'll do with the merits is another question. But you can't just let them sit there. The other thing that we're seeing, and Jay's point on the voting rights is really, really important, because if you can delay effective enforcement of constitutional protections, including voting protections, then you can delay protection against unconstitutional illegal action to restrict voting, to alter voting. What if he issues an executive order saying you can't vote by mail? What if he issues an executive order that says, hey, you must produce identification of the following types to be able to vote at all? There's almost no limit. There's no guardrails. That's the problem.
We see news media coverage like the O.J. Simpson on the Diddy criminal case. It just seems to me that the media is not really picking up on the seriousness of this Supreme Court decision. Is it that the media doesn't understand the impact, or are we just drinking some kind of Kool-Aid and we're upset about it? Chuck,
Eh,
what's going on with the media coverage on this very important issue? Because I'm not seeing a whole lot.
Same thing that's been going on for the last approximately 8 years, right? Is hey, they're covering the reality TV, and they're not covering the substantive issues. They're not covering the rights of vulnerable people. They're not covering the rights and interests of the citizenry. The only thing that gives any attention to public opinion is polls that have been so beaten to death they're a dead horse.
Mm-hmm.
Hey, they really carry no influence anymore. Hey, and so I think anyone that expects the current mainstream media, including New York Times, Washington Post, and any of the others, to protect the rights of citizens, to protect the rule of law, I'm not seeing the basis for expectation of that.
All righty, thank you. Hey, David, the second this ruling, Trump versus CASA Inc., was issued, Donald Trump took to the media and said, this is a fantastic decision, and we're going to go after those previous decisions that blunted our actions against universities, against legal firms, against the issue or the concept of due process for undocumented immigrants. Does it stop there? Do you see other challenges on the immediate horizon that Trump may try to attack where he's been blocked in the last 5 months? Do you see any other opportunities for Donald Trump?
He's issued a lot of executive orders, and many have been enjoined. So he's got a lot to pick from to go back just in past recent history, to go back and start enforcing those executive orders. That being said, there's opportunities to do a lot more damage. And as Jay says, voting rights is one in particular that would be tremendously damaging to cut back on voting rights. So I think that it's a full court press. It's like we're going to try and do everything we can to ensure that people of my ilk get reelected. And if that requires shutting down voting opportunities, expanding the ability for very rich people to fund electoral campaigns, we're going to do everything possible to expand and ensure an election victory for us going forward for every election we can. So yeah, I think it's really very frightening. And again, as I mentioned earlier, I think there are tools to rein this in, but unfortunately, we have a Congress that is probably one of the least courageous we've ever seen. And even when confronted with the facts, people put numbers in front of people that you're going to hurt tens of thousands of people who voted for you. You're going to betray them. They go then and betray them and vote for the current bill. So yeah, you can impeach a president for constitutional violations. That's not going to happen. So it's a scary time. Speaking about, I think one of the problems is that this recent Supreme Court decision has been explained as not deciding, as we've observed today, the question of birthright. And instead it's been described as, oh, it's just a procedural step. And so people say, oh, okay, it didn't decide birthright. So I guess it really wasn't as important. It's just a procedural step. The consequences of the decision, I don't think, are being well explained. That's where I think the media is missing. So they report it as, yeah, it's just a procedural step. They'll get to the birthright question soon. Stay tuned. But they have not really expanded and explained the kind of all the doors that have been opened up by this decision. So I think, yeah, the media has really failed in that respect.
Well, I have three gentlemen here that have opened up the doors, and they have explained it quite well. We've run out of time, so before we conclude, I'd like to go around the table, starting with you, David, as to your final thoughts on this topic.
Since we're quick, I just mentioned one other final topic. You know, for all the budget hawks in Congress to pass legislation that's going to increase the national debt to unprecedented levels is so unbelievable. It's almost as though it's out of a novel. That's got to be fiction. It can't be history. But that's what we're witnessing today. And again, my fear is that until the chickens come home to roost and people are getting hurt personally by what's happening, they're just not reacting yet. And I'm sad that it takes that long for people to understand the damage, but apparently that's what we're seeing. Until it hurts me, I'm not ready to do anything about it.
Good point. As you were speaking, my mind was racing off to Charles Dickens' book about A Tale of Two Cities, and we may soon see that. So, excellent point, David. Thank you. Chuck, your final thoughts on the topic.
I think it's become clear that, at least at the upper levels, the courts are not going to protect the citizens whose rights are at issue and vulnerable and subject to harm and being taken. Certainly the executive's not. They're the guys who are taking them away. So unless it happens in effective voting and elections and they're enforced, I don't see how the tide gets turned.
Okay. That's a gloomy thought. Thank you, Chuck. Appreciate it. Jay, you get the final word on this.
I have two words to carry away from this. One is the word emboldened, because if he's been liberated now from constitutional restraints in a de facto way, and he recognizes that, he wanted that, and they wanted to give him that. So between this and Citizens United and some of the other ridiculous cases that the Supreme Court has issued in recent years, he is a unitary president. He is a monarch, a dictator now, and he can do what he wants, and the Constitution is of no restraint. But what's worse than that is the whole psychological effect of being bold, being emboldened. That I suggest to you that we are not only going to see a continuation of the kinds of things that he has done, the unconstitutional edicts that he has issued, we're going to see things that are far worse. Okay, and one last point, and that is chaos. That's my second word for the day. Because when you do this sort of thing, as in the case of so many of the Supreme Court's other decisions in recent years, you create chaos in the community and the country. This one is going to create chaos too, legal chaos, judicial chaos, and legislative chaos. So let me offer you a really chilling thought. The elections come up in 2026. Trump says, we have an emergency, mouse that roared kind of emergency. It's a phony emergency, but I have declared it an emergency, and I am delaying the midterm elections, okay? For how long? And here's the big question I leave you guys with. What happens during the delay? Well, there's no change in the configuration of the House or the Senate. It stays the same. So we are that much further from changing things around to avoid these awful results we're getting from the Supreme Court. It's going to remain the same for as long as Trump can delay it through, moving into this kind of chaos. That's my final thought.
All right. Well, gentlemen, thank you for an excellent discussion. Thank you for opening horizons to think about the consequences of the Supreme Court decision. I think this discussion is doing a lot that regular traditional media is not really doing, except for interviews with Lawrence Tribe, scholar of the Constitution at Harvard. But other than that, I'm just not seeing a lot. So thank you for highlighting this and expanding our awareness. I'd like to thank my special esteemed guest, David Larson, and our other special esteemed guest, Chuck Crumpton, and of course, always my co-host, Jay Fidel. This is American Issues Take One. I'm Tim Apicella, your host. Join us next week. And until then, aloha.